to give everyone a heads up this evening. We are recording this session so that we can post it on our website. So for some reason, if you need to drop off, you can go back and watch the rest of the session later. But welcome everyone, and thank you for joining us this evening. My name is Lauren Higgins. I am with the Committee for Special Education of Lower Merion. I, along with my my partner in crime on education, Jenny Knox, she and I are responsible for the education series that comes to you. This evening, I am going to be partnering with Marta on delivering this presentation. And I see that our speaker, Judith, has joined back up, so that's great. We'll have Judith come back, and then I'll finish doing her introduction. Hi, Judith, are you back with us?
I couldn't before.
Yes.
Oh, good. You can hear us now?
Yeah. That sometimes happens.
No worries. No worries.
I have to reboot my computer.
No, that happens a lot for me too, especially when you move from place to place during the day. But thank you so much. I'm gonna, I just was giving everyone a, sort of a welcome from the Committee for Special Education. And then I'd like to do a brief introduction to you. Everyone, again, thank you for joining us. We're delighted to have with us tonight Judith Gran. She is a leading attorney in the area of special education, and I'll give you a little bit of background about Judith. Prior to joining Reese, Corolla, Gran, and Zuba, Ms. Gran practiced law at the Public Interest Law Center of Philadelphia from 1984 to 2009. She served as Director of Disability Projects from 1989 to 2009. She has conducted class action litigation to obtain community services for institutionalized individuals with intellectual and developmental disabilities in Pennsylvania, Connecticut, Oklahoma, New Mexico, Montana, California, Illinois, and Tennessee. That's certainly that's a lot of bars to be admitted to, Judith. Ms. Gran represents special education students in administrative and judicial hearings, judicial proceedings in Pennsylvania, New Jersey, and other states, most recently West Virginia and Iowa. These cases include the class action lawsuit Gaskin versus the Commonwealth of Pennsylvania, a case brought to enforce the least restrictive environment mandate of Individuals with Disabilities Education Act IDEA that resulted in a statewide settlement agreement. So with that, I'd like to welcome Judith with us this evening. We're delighted to have you. Thank you so much for making time at the end of your day for us and for our parents. Our parents represent the Lower Merion community and surrounding communities in some cases. So we're delighted to have you. Would you like us to share, your screen to show your slides to start?
That would, okay. Okay, well, what I thought I'd do is go through some of the cases that have come down so far, interpreting school districts' obligations in the time of COVID. And obviously, things keep changing. There aren't, as far as I can tell, any set of general principles so far that everyone is following. But there was some clarity, I think, in the U.S. Department of Education's response to COVID. You probably remember that in the CARES Act, Congress provided that the U.S. Department of Education could waive provisions of IDEA, and that was quite controversial because there was a fear that the Department of Education would waive FAPE to some extent. And it didn't. It chose not to. So that's, I think, the basic principle that we start with is that students still have a right to a free, appropriate public education, no matter what. And that means the services in the student's IEP. And unless the parent and the district agree to modify the IEP, it remains in effect. And I think the basic principle that I'm seeing in the cases is that school districts have to figure out ways to make those services available, even though it's not particularly easy. I'm just going to quickly mention some general provisions in Pennsylvania law, school law, that apply to emergencies, which basically give school districts a lot of latitude to shorten the school day. They can do a lot as long as they don't waive the 180 school days requirement.
So,
Okay,
Judy, let me know when you want me to move ahead, Judith.
Yeah, next slide. So this says that instructional time means time that is spent in actual instructional activities under the direction of certified school employees. That's really important because we're hearing from some school districts, they're recommending that where a student has an aide, for example, that the parents make arrangements to get a TSS from the behavioral health system or a home health aide, and those would not qualify. Okay, next slide. Can move to the next slide, thanks. And the Pennsylvania Education Code says that instruction may be provided in synchronous or asynchronous formats, which is a little troubling because not all students can benefit from asynchronous instruction. Next slide, please. Yeah, this is the provision that says the 180-day requirement can't be waived, but the school day may be shortened. Next slide. Okay, there are a lot of issues coming up around one-to-one paraprofessional support. And the PDE guidance, the Pennsylvania Department of Education, has said that if an IEP includes a personal care assistant as a related service, and the school district is using a blended or remote learning model during the present school year, that service must be provided one way or the other. Next slide. And if the child can't come to school, it has to be provided in the home. Next slide. The only way that that could be eliminated is if the IEP team determines that a personal care assistant no longer is appropriate for the student. And the parents, being members of the team, obviously would have a say in that and could challenge that. Next slide. So if the student can't go to school and has to receive the PCA service at home, the LEA should ensure that necessary protocols and hygiene are in place prior to providing the support. And that is the LEA's responsibility as I read the guidance. Next slide. So if the health and safety situation is such that in-home supports can't be provided safely, this should be considered as part of compensatory services, and we'll get to that. But the district is going to have to consider how to make that up. This is a complaint investigation report from Indiana, which is interesting on this issue of one-to-one support. Next slide. The Department of Education in Indiana found that, again, the principle, school closures do not relieve school districts of their duty to provide students with FAPE. And by the way, in relation to the guidance or the regulatory requirements in Pennsylvania that I went through first, you may be wondering, is Pennsylvania different from Indiana in that Pennsylvania says you can have a shortened school day and you don't have to provide everything the same as what you did before? Well, the difference is that this is about the Individuals with Disabilities with Education Act, which is federal law, and federal law trumps state law. So regardless of what state law says, school districts still have to provide a free, appropriate public education. Okay, next slide. So this school district stopped instructing students in person. They closed the schools, and the Department of Education said that the school district should have assigned the student a special education assistant who could provide the support that was in the IEP, the number of minutes in the IEP. And this particular student had an aide to support her in general education classes. Next slide. And by the way, please feel free to interrupt and ask any questions you may have as this goes along. So she was supposed to receive 120 minutes a week. Can go to the next slide. And she was in e-learning at the time for virtual instruction. Next slide. And the district was not doing nothing. They were checking up on her. They were looking at her progress, but she did not receive that 120 minutes a week that she was supposed to get. Next slide.
Judith, just to clarify, so 120 minutes a week, so essentially 2 hours of one-to-one support a week. Do you recall what age the child was? I'm just curious if it was a young child or.
It was a young child.
Okay, so maybe elementary school?
Yeah. But this was just, she apparently only had the aid when she was in general education classes.
Oh, okay, so she was only general ed 2 hours a week.
Right, so that's why it was limited. And the State Department of Education found that the general ed teacher and the special ed assistant had contacted the student to offer academic support only 4 times in the month of April. And they said that just was not acceptable. So the basic principle again, you have to implement the IEP as written unless the parent gives you permission otherwise. Next slide. So the remedy that the State Department ordered was to convene the IEP team to determine compensatory services in the form of academic support by an aide for that 120 minutes a week whenever it wasn't provided. So the student got compensatory education as a result. Next slide. They also ordered, as part of the remedy, that the school district send a memo to everybody in the special education program, telling them that they have an obligation to implement the IEP as written, and then document that the memo has been distributed. Next slide. Another issue that comes up is behavioral support. And here's another complaint investigation report. This one is from Colorado. Next slide. And here the homebound teacher was apparently going to the student's home, but failed to provide the behavioral supports and interventions required by the IEP. And the teacher's timesheet showed that she instructed the student only in reading, writing, and math. So there's no documentation of the behavioral support or other subjects. And I expect that this was probably because the homebound teacher did not have the expertise to provide the behavioral support in the student's IEP. Next slide. And this prevented the student from making progress on his social and emotional IEP goals, and therefore he was denied FAPE, which raises the question, what if he had made progress? Would that be okay? And there's another case from another jurisdiction that does kind of answer that question. Next slide. So there are some cases that deal with in-person instruction at home. One is from Pleasanton, California, where the student's IEP pre-COVID was not being implemented, and the parents asked an administrative law judge to enforce pendency or stay put. And the ALJ ordered the district to provide in-person services at home if necessary, including a one-to-one licensed vocational nurse, speech therapist, PT, and vision services. And the student wasn't actually asking for everything in the IEP, so it was basically limited to related services. Next slide. Okay, on compensatory education and COVID compensatory services, which is a new thing that school systems have come up with. As you all know, compensatory education is the remedy that students are supposed to get under IDEA, and it could be under Section 504 as well, if they don't receive the services in their IEP. They don't receive as much in terms of services as are in the IEP, if a service isn't provided altogether, if they don't receive appropriate services, if they're not getting an appropriate education. And you can also get compensatory education for denial of services in the LRE. And there have been a number of hearing officer decisions in Pennsylvania that have awarded compensatory education for students who were unnecessarily placed outside the regular class. And I would say that's a common principle in this jurisdiction, the Third Circuit. You can also get reimbursement sometimes under certain circumstances for being denied services in the LRE.
When you say, I'm sorry to interrupt, can I ask Judith a question? Sorry. When you say reimbursed, I mean reimbursed for, I mean, if the school district's paying for it, then what would you as a family get reimbursed for?
You as a family could get reimbursed if the school district refused, for example, to place your child in general education classes to the maximum extent appropriate, and you told the school district, okay, I can't accept that. I found a Montessori school that is willing to educate my child in regular class for the entire school day. And if you tell the district that you intend to seek reimbursement for tuition there, and it's determined that what the district was doing was inappropriate, that they weren't educating the student in regular class to the maximum extent appropriate, the family could be reimbursed for the cost of the private school.
That's helpful. Thank you.
So COVID-19 Compensatory Services is something that the Pennsylvania Department of Education and some other departments of education have come up with to cover the situation that we're in with COVID. And it's defined as services that are identified by the IEP team that are needed to represent regression, to remedy regression, loss of skills, or lack of progress that resulted from the LEA's inability to provide FAPE during school closure. And this is interesting because regular compensatory education, as you know, is set forth in the case law under IDEA, in our jurisdiction, in the Third Circuit, the courts have said you can't leave it up to the IEP team to decide, because the IEP team was responsible for the students not getting FAPE in the first place. So it has to be decided some other way. If the parent doesn't agree to what the school district wants to provide, you could ask for a hearing, and a hearing officer would award compensatory education. And usually those orders say that it is the choice of the parents as to how that compensatory education should be provided. They can go out and purchase the services, arrange for the services to be provided by anyone who's properly certified, and the district would have to pay for it at market rates. So this is a departure from that. And I think, you know, there's a little bit of a struggle around the idea of that lack of progress would trigger compensatory services. PDE has said, yes, it does. But they, and I think many school districts, are really focused on regression. And if there's no regression, I think there's not quite the enthusiasm for providing COVID compensatory services. So next slide.
I have a question in terms of measuring regression. If there's a situation that during the school closure, there was lack of reporting of progress during the period of closure, like no progress reporting was done or it was void of any data, then where is the baseline data to measure from which there is regression or not regression, to then have that starting point to determine if compensatory services are deemed are to be awarded?
Right. Well, I think one answer is that progress reports are a requirement of IDEA. And I suppose that would be considered by most hearing officers a procedural requirement. But if that procedural requirement results in substantive harm to the student, that is, you don't know whether the student has made progress or not, and you can't plan for the student in the future, I think that would be considered substantive harm, and the student should receive compensatory services. However, the Department of Education has said that when in-person instruction resumes, school districts are supposed to do some sort of baseline inquiry. And they could do this by looking at the students' present levels in the last IEP or the last progress report, seeing where the student was, if it's possible to do that, before in-person instruction stopped, and then do whatever assessments are necessary to figure out where the student is now. So I guess it looks to me as though the Department of Education is imagining a safe harbor for school districts. If they find a baseline somewhere and then do an assessment, they wouldn't necessarily have to rely on the students' progress reports. That still is a violation, whether they figure out some other way to award compensatory services or not. So I just want to emphasize that. And another interesting thing about this concept of CCS is that according to PDE, the school districts have to consider this only after the student is back to receiving services as set forth in the IEP for some period of time after the IEP is fully implemented. And PDE has been calling this the recoupment period. Next slide. And recoupment is a term that comes from extended school year. One of the criteria for eligibility for extended school year is whether the student exhibits regression and recoupment after a break. So it's not exactly applicable, I think, to regular special education during the year when you're not supposed to have a break and you're supposed to be making progress on your IEP goals, not this kind of stop and start. And PDE has said that school districts can make these decisions about COVID compensatory services at any time within the first 3 months of going back to school and providing in-person instruction or synchronous instruction in a remote learning environment. Next slide. So the idea is that 3 months is what it should take for the student to regain or recover lost skills or behavior. And they do advise school districts to prioritize the students who had the greatest difficulty accessing FAPE in the remote learning environment. Next slide. And the thinking is that this will give the student an opportunity to recoup the lost skills and make progress to the degree that was considered appropriate. That's not, again, it's not really consistent with the way compensatory education is usually looked at in Pennsylvania, where we look at the number of hours, the number of minutes, the number of therapy sessions lost, the number of days of school, the number of classes. In some other places, they do look at progress. And if the student didn't receive the right services but still made progress, there are courts and hearing officers in other places who have said that's okay. But that's not really the way it's done in Pennsylvania. Next slide. A failure to implement the IEP usually results in compensatory education. Next slide. This is a complaint investigation report from South Dakota. And the Parents allege that the school district failed to implement the IEP while the schools were closed. And the State Department of Education found that there were only minor discrepancies between the services provided and those called for by the IEP. Next slide. And they looked at the service logs and progress reports that indicated he received services twice a week, but not to the same amount of time that was in the IEP. In Pennsylvania, that would be a no-brainer. You would get compensatory education for that. Next slide. But the student was doing well. And I think in the previous slide, it mentions that the student was doing okay, was making progress. So the State Department of Education thought he should not receive compensatory education. He didn't need it because he was making progress. And again, I don't think the result would be the same in Pennsylvania. And I think that's the end of the slides. Oops, sorry. There's a few more. Oh, this is a case from the District of Columbia, their state educational agency. And in the District of Columbia, they look at progress to determine whether you're entitled to compensatory education. And they try to figure out how much progress you should have made and then award the services you need to achieve that progress. Next slide. And here the school district offered no speech therapy during April, but offered therapy during the month of May, not quite enough to make up for what had been lost. Next slide. And the State Department of Education, or the District of Columbia Department of Education, looked at the U.S. Department of Education guidance. And this was some of the earliest guidance that the U.S. Department of Education provided. And they said that if the school district is not providing education to anybody during the COVID outbreak, they're not required to provide special education services. So next slide. And the parent did not present evidence that the general student population was receiving any services during the month of April. And then the State Department of Education went on to say that even if general ed students were receiving services, the loss of 1 month of services was not material. And that's sort of the exception that we're seeing in some decisions, that loss of services has to be material or substantial. It can't be just, a missed session here and there. And here the district made up some of the sessions, but they didn't make up all of them, which could be important. Not to mention the importance of continuity of speech therapy. Just not doing it for a whole month could be quite disadvantageous to some students. The issue of students who can't benefit from virtual instruction. Next slide. This was a case from New York City against the, and here the student, the school district is offering remote services, which the student was not benefiting from. And They just weren't designed for that student's particular needs. And the parent had already been to court and gotten a stay put order to the school district to implement the student's IEP from 2019. And the order said, to the extent that services can be performed safely in light of the pandemic. Next slide. So the school district blamed the parent and said they were willing to work with her to try to set up computer-based services, which she didn't have. She lacked a computer. She didn't have internet access. They were willing to help her work all that out. And the court said, or the hearing officer said, it's not appropriate to blame a single parent with 2 kids who have autism, who's poor, for not making herself available to the IT department so they can troubleshoot the device. And the court said that he knew from experience that this can take a long time. This might take all day. So don't expect the parent to be at your beck and call. And here's one from Philadelphia. This is an interesting case. This is a hearing officer decision from Pennsylvania. And the school district had tried to get the request for compensatory education dismissed on the grounds that they weren't back to school yet. The process for determining COVID compensatory services had not run its course, and so the dispute was not ripe. And the hearing officer held very simply that the process for identifying COVID compensatory services is an alternative to compensatory education. The fact that you can do it does not mean that parents are not entitled to seek compensatory education under the regular legal principles. So that was a very important decision, and I think that will be an issue for many students going forward. Okay, I think that really is the last slide now. So any questions?
So Judith, there's some questions remaining just from the questions that were submitted.
Yeah.
They both relate to the hybrid environment.
Right.
One of them being, what if there are needs of executive functioning that don't translate well via Zoom, via how we're having this meeting? What are the FAPE obligations of a school district so that a student is properly supported in the hybrid environment when they're spending part of the time at school and part of the time at home?
And do you think that student would be having trouble in the remote environment, but school will be okay?
That's what I'm gleaning from the question. I'm just reading the question as submitted.
Right. Well, I think that goes back to the New York case that I mentioned earlier, LV versus New York City, where the court, this was actually a decision in court, basically held that the school district has to provide the student with instruction in a way that he can benefit from. So if the student's executive functioning issues prevent him from benefiting from remote instruction, either they can send somebody into the home to work with him, or they could offer him more days of school. And I have that case right now, actually. And I'm trying to negotiate more days of school for a child with Down syndrome who also has a lot of attention and executive functioning issues. And the district is only willing to offer the same amount of hybrid instruction that they're offering everyone else. So we'll see what happens.
Mm-hmm. we have a similar question for other skills like social skills that don't translate well over Zoom, and whether the school district should prioritize those skills versus the academic needs in the hybrid environment. I'm assuming it sounds very similar to what you were just talking about.
Yes, yes.
Okay.
Well, that would certainly, if the school were smart and if it were planning this carefully, I think they would try to prioritize instruction in social skills and exposure to peers with opportunities to practice those skills in the hybrid environment. But if they can't do that, if they can't work that out, I think they would have to adjust their program, however makes sense, so that the student can receive those social skills. And remember, there was a case that I mentioned in which the student was getting academic instruction, but he wasn't getting social and behavioral intervention. And they found that that was a violation and that he was entitled to compensatory services for that.
Thank you. So I have one or two more, but I want to make sure that the folks who are attending, if they have a question, they can submit it via the chat, and I'm monitoring the chat as well. If you're interested in sending a question, please do so. If not, I'm going to continue down the list of some of the questions we had left behind, just making sure everybody's mindful of that. So another question is, in this whole aspect of the recoupment and the regression of the compensatory services, is there a requirement that, for example, the Pennsylvania state is requiring schools to follow a particular process of communication with families and documentation and assessment of the baseline, the recoupment period, and then a determination of recoupment services for every single student that has an IEP? Or is this on a case-by-case basis if the team decides to gather and so forth? Can you maybe give us a little more structure around what is mandated by the state?
I think it is required for all students. Mm-hmm. And the state has left it up to school districts to figure out precisely how to do this. There isn't a standard protocol that they are required to use, but they've been instructed to collect baseline data or go back and find it if it exists, and then do an assessment. And they've given some guidelines or examples of what they could be doing. I guess curriculum-based assessments would be a good way to do that.
Got it. And are going off of that, we're aware that the state awarded several grants of compensatory funds to various school districts. Do you have any insight as to why the amounts of dollars were different for school district, or was it they applied and they got X, or the state made those determinations?
I don't know how that was done. Okay. That is a mystery.
Got it. Okay, we got one from the crowd through the chat. What should a parent do who may have made the decision to stick to the path in person? So waiting for the school to reopen based on their decisions so the question is, what should a parent do who may have made a decision to stick to the path in person for the IEP support reasons to stay with homeschool managers and made the choice based on safe metrics previously given, but currently may feel unsafe returning to school? Right. Can parents keep their kids at home, but in their homeschool, if parents provide 100% full day synchronous education for kids based on work given by their certified classroom teachers?
I think so, yes. I think safety trumps everything.
Mm-hmm. So if parents have made the choice of doing the online version of the school for safety reasons, yeah, the school still needs to provide everything in the IEP and needs to figure out a way to do it.
Yes, exactly.
Okay.
Exactly.
Okay. Next question. If both parents have to work and the kids are doing the online school, should the school provide in-person services to support the student, or are the parents responsible for this?
Well, where are the students? The students are they in a hybrid environment?
I think this is implying that they're in the online at home school the whole time.
Online and homeschool, okay. So ordinarily the students would be at school
Mhm.
and there would not be a need for somebody to be with them. Hasn't Lower Merion addressed that issue in its FAQs for parents?
That if both parents have to work and they decide
Yeah.
to take the at-home school, should the school provide support services at home, or the parents?
Yeah.
I sincerely doubt they have addressed that FAQ, but
Okay.
these get updated frequently, and I haven't checked them in the last few days. But maybe that's a place to start.
Well, one solution would be for the parents to, are the parents willing to have the student go to some other setting during the day? Like I know some parents who are sending their kids to a YMCA during the day where they can access virtual instruction at the Y, and they can get, supervision and support there. And in Philadelphia, they have set up, we call them drop-in centers, but they really aren't because you have to make an appointment. But, there are places where parents can bring their kids and they can access online instruction there, even though the parents are at work.
Okay.
So I have not found school districts terribly receptive to that. I guess they will say, well, if the parents can work that out with the Y or whatever agency they can bring their children to, that's okay. But I know one family whose child needs an aide, and they wanted the school districts to provide the aide at the YMCA, and they wouldn't do it. And they kind of worked out a compromise, so that isn't a live issue now. But certainly that, there are possible solutions, I think.
Here's another question. It's not specifically stating the COVID-19 situation, but it relates to extended test taking and what are school districts required to do under FAPE as it relates to accommodating for extended test taking. I think that sounds more general, but might not be COVID specific, but.
Oh, it's very relevant though, yeah. Well, you have to, the school district has to provide the accommodations and the specially designed instruction and supplementary aids and services in the IEP. Those are integral parts of the IEP. So I would say yes, they must do that. However, I did see a complaint investigation report that found that that basically let the school district off the hook for not providing all of the specially designed instruction in the student's IEP. But I think something like extended time for testing is so basic and fundamental that they would have to provide that.
Yeah. I want to clarify while we wait for another question to come in. I want to clarify what I thought I understood from the beginning of your presentation, which was if during the closure, the services as outlined in the IEP were not provided and the IEP itself was not changed to reduce those services, that means the school district did not provide FAPE, right? And that is a path to compensatory education.
Yes.
Okay.
Definitely.
So if there was no rep signed, no IEP revision was made.
Right.
Okay.
Right.
Okay.
Now, school districts are issuing NOREPs. I don't know if this is happening in Lower Merion, but I'm seeing school districts are issuing NOREPs for every little change that's made. And of course, once a parent agrees to the NORAP or doesn't challenge it, it becomes the stay put placement. So I think it's very important that parents not enter into any permanent change in the IEP during this time.
Okay.
Unless, unless they can agree with the school districts on how to handle this.
Mhm. Is there any guidance from the state or the federal government in this remote time on how documentation in terms of attendance to IEP meetings and signature pages and so forth are being documented so that there's a true record of who really attended when these meetings are now being done virtually?
Oh, yes. Yes, PDE has some guidance about that. And basically, they have to document it, and it has to be done in a fashion that's reliable so that you can prove whether somebody was there or not. So yes, that's important.
Okay. Making sure people have a chance to send in. I'm monitoring the chat as I look at Judith, trying to master both eyes. Okay. Oh, I could sit here for an entire hour and a half and keep asking you questions. So
Feel free.
let's see what else we can think about. Evaluations. Any recommendations or words of wisdom on evaluations in this transition time, reevaluations, and whether there's any guidance on how things can or should be done as the reopening progresses?
Yeah, the timelines are not waived. So school districts have to do evaluations and reevaluations according to the timeline. And obviously they have to do it in a way that's safe. And this has been problematic for certain types of evaluations. But, there's been nothing to really let the school districts off the hook.
Okay. Trying to think about what else. Could you go back again, maybe to expand on the discussion we had about when you were talking about the progress reporting, and if there was no, when progress reports were provided, they were void of data, then what are districts then looking at using the last documented piece of information as their original baseline to compare against the new baseline that they collect as part of this compensatory process?
I think what they would do would be to look at the IEP and the goals in the IEP and what was stated in the IEP about how much progress the team expected the student to make. And, often students don't make the progress that is contemplated by the IEP. And under IDEA, if that happens, if the student isn't making the expected progress, the team has to go back and look at the services that are provided, and maybe change the services, maybe add more services, do something differently, maybe revise the goals. But there is, a pretty powerful obligation under IDEA. If a student isn't meeting the goals in his or her IEP, they have to make some fundamental changes. So I think if there are no progress reports, I think what should happen is that they take the IEP, the last IEP, whatever goes through this point in time when the team is trying to figure out how much progress the student should have made, and then do an assessment. If that's the only way to establish what the student should be doing now. If there's no baseline that's current enough to really establish that, that's what you can do. And then the school district would have to assess the student to see where he is now and compare with the lack of expected progress.
Got it. Thank you. Okay, let's see if there are any more questions. I don't see any more. Are there any closing thoughts, comments you want to make based on now that schools are starting to a month into it, and what are you starting to see, or kind of closing remarks for parents to know what to keep an eye on as the year progresses?
Well, I think there seems to be a really huge issue with the provision of one-to-one support in various forms. And I think that seems to be a huge struggle in some school districts, at least. I don't know if that's true in Lower Merion, but that's certainly something parents need to be vigilant about and really know their rights and what they can request from the school district.
Okay.
An issue that I think a lot of people struggle with is modifying the IEP. And if under U.S. Department of Education guidance, if you change the provision of special education services in any way, you are supposed to issue prior written notice, a NOREP in Pennsylvania. And then, you know, as I said, that triggers, that becomes the last agreed upon placement. And that could make it hard for parents to go back to an IEP that provides all the services their student needs. So I'm very wary about that. And in Philadelphia, they have these digital learning plans that somebody asked about. That was a question that you all submitted, and that's, as far as I can tell, a Philadelphia thing. And it's supposed to be a plan that is designed, customized for the current hybrid situation, or in Philadelphia, they're still not even back to hybrid yet. But they're doing it in a way that doesn't override the NOREP or the IEP. However, the big, huge problem is that school districts are not providing, the school district is not providing any modification or supplementary aids and services in these plans. They're very generic. They're just kind of the general curriculum with a sequence of activities, and they describe the activities pretty specifically, but they don't build in any special education support for students. So I think that's a huge area for students who are in general education for most or all of the school day. Getting the support that they need is another area where I see a lot of difficulty with implementation.
Okay. One more question that I just lay my eyes on. In the situation of a parent where they're in the virtual program provided by the district, the child requires a one-to-one parent support for the child to be able to pay attention. And obviously it isn't feasible long-term. What suggestions do you have to get full support from the district?
Does the child need that support only in the virtual environment?
That's what I'm taking from this. It says child requires one-to-one parent support for the child to maintain attention, which isn't feasible long-term.
Right, parent support. Well, if the student, you know, I would again go back to that New York case where the court basically said, this is not the responsibility of the parents. there are some children who are going to need that support in the virtual environment, and you cannot depend on parents to provide it. You know, we wouldn't, under normal circumstances, we wouldn't ask a parent to provide that support.
In the school.
Yeah, in the school or anywhere. If the student were on homebound instruction, you know, the student would be receiving services by certified school personnel at home. And I'd go back to the Pennsylvania the Pennsylvania regulatory statutory definition of instruction, which means it has to be done by certified personnel. Whatever the parent is doing doesn't count.
Mm-hmm. So the person added a little more detail. The student doesn't require a one-to-one at school, but at home, the student does require it. What are their options? Can they hire somebody and request reimbursement?
Yes, yes, they could do that.
Is it going to be an easy road, though, to get the reimbursement?
It would be an easy road. In fact, some school districts are offering that. They're offering that because they don't want to send people into people's homes. And there's one school district that I know of, Tredyffrin-Easttown, that has kind of a standard package that while students were on, when instruction was all virtual and there were students with aids who needed aids, they were sending parents settlement agreements in which if they signed it, they would agree not to ask the district for an aid, but take $3,000 to pay an aide that they hired themselves. So it certainly is feasible for school districts to do that.
It's a matter of whether they will do it or not. I think
Yes.
it's interesting to hear that TE is doing it. It's a matter to see whether other districts will follow, although other districts will follow the same path. Okay.
Well, there are going to be situations like this that will be taken before hearing officers in the Office of Dispute Resolution. And frankly, that's probably the only way to resolve some of these difficult issues, because school districts obviously have personnel problems getting their staff to agree to go into people's homes.
Yeah. Okay. Alrighty. Well, Judith, we really appreciate your time and your wisdom and your years of experience and caring for your profession. Thank you very much on behalf of the Committee for Special Education at Lower Merion. Thank you for giving us your time, your insights, and for looking out after what all the parents in this call are interested in, our children.
Thank you so much for all the great work that you're doing and the wonderful support that you're giving to other parents. This is a great model of parent-to-parent peer support. And I hope that it goes well for everyone in this coming year.
Thank you very much. Good night.
Good night.